Thank you, Michael, for the presentation. I will speak today about the slogan, "Nothing about us without us." It's a slogan that the disability movements around the world carries and demand. And what I would like to do is to turn this inspirational slogan into a framework of analysis and think what it means to advocate a nothing about us without us approach for law, policy, and bioethics specifically. The history of this slogan is a quite short history. For people who are familiar with the slogan, it's not always known where it comes from. So James Charlton published a book in 1998 that carries this title, and James Charlton heard this slogan in his travels around the world when he interviewed disabled people, but he actually heard it from socialist social movements, people who were fighting, as he said, over self-representation and control over the resources needed to live a decent life. So for James Charlton, the disability movement is not different from other movements who demand self-representation and control. And this is the basic component of this slogan, "Nothing about us without us." Now, the disability challenge in general for law, policy, and bioethics, I think it carries involves two components that are important to understand, and that they inform one another. The one is a substantive challenge, a substantive demand for a new understanding of disability. To think of disability as an interactive, contextual, and relational social phenomenon, and not as a fixed trait or a scientific fact. The second component is a process component, which is a demand for a new place for disabled people as active participants in decision-making processes. Usually when we talk about disability rights, we talk about the substance of disability rights. When we talk about nothing about us without us, I want us to think about the process, about what it means to give a new place for disabled people in decision-making processes. Now, my talk, just like a short theoretical comment or context, my talk stands on two legs, has two major components. One is the disability rights perspective, and the other is the disability studies critique. And when we think about what it means to develop a theory of disability, I think that we need to think or consider both. One is the disability rights approach that actually views disabled people as a minority group that deserves civil and human rights. And the second is a disability studies critique, which is a critical theory approach that views disability as a social construct that is shaped by social, cultural, economic, and political processes. And these two perspectives actually inform our new understanding of disability and of the place of disabled people in society. What the disability critique involves for this lecture and in general, and I know that some people never heard about the disability critique, so it's important to lay some grounds for that, is the new understanding of disability actually seeks to replace the old understanding of disability as abnormalcy, pathology, or tragedy, to a new understanding of disability as human variation, as part of the human experience, as not as abnormalcy, but part of the normal, of the variation that we have in society, as part of human growth, human development, and as events that could happen to each one of us throughout life. A second component is a new understanding of disability, not as a burden, but actually as a potential for the disabled people who can contribute and have a contribution for society. It's not only a human variation, it's also a positive component in life that people with disabilities can contribute to society, and they are not a burden or something to get rid of as the eugenic approaches used to think of disability, and they still continue to affect our understanding today of disability. Another thing is the turn from medical and experts' knowledge into experiential knowledge. So especially for this conference, it's important to stress that what the disability challenge to bioethics, that the major challenge of disability to bioethics is to give more space and more weight to the experiential knowledge of disabled people and not only to the expert knowledge of physicians and other health professionals and experts. A life with disability, within this understanding, within the disability studies and the disability rights discourse, is life that is worth living. Quality of life is higher than assumed by non-disabled people, and it can be higher with equal rights. So it's not only that we should feel sorry for these poor people and let them live among us, but we should think highly and positively of the possibility that people with disabilities can have in society if society is more open and more accessible. The emphasis is on access and support. So it's not only about being independent, it's also about being interdependent. It's about what kind of support society gives to disabled people in order to be able to live independently and to pursue their lives or dreams or to make decisions concerning their own lives. So if we go back to the slogan, nothing about us without us, the theoretical framework that I suggest here has two dimensions. One dimension is an individual dimension, which deals with the enhancing of personal decision-making with the enhancing of personal decision-making concerning one's own life. So when we think about nothing about us without us, we want to give the individual the opportunity to make decisions about his or her own life in every sphere of life. The other dimension is a collective dimension, which is concerned with the facilitation of participation of disabled people in public deliberation processes. So here it's not only about my own life, it's about the generation of norms and policy making and how to allow disabled people to take part in public deliberation processes that may affect their life eventually. Now, these two components are highly connected because if individuals cannot make decisions about their own life, they cannot become part of the public process. And if they are not part of the public process, so their own options are more limited. So there is a dynamic here that one influences the other. And my theoretical framework is this, and I will develop it in a minute, but when I discuss individual dimension, I would like to emphasize voice, access, and range of options. And the collective dimension involves the question of who is without us, what is about us, and how can we include a range of voices. If we talk about, in the individual dimension, we talk about range of options. Here I would like to emphasize range of voices. And the individual dimension is mainly about choice, while the collective dimension is mainly about representation. And both of them are part of the nothing about us without us slogan or phrase that we hear a lot in disability struggles. Now I'd like to start with voice. Yeah? So I'm in the individual dimension, and I'm talking about voice, next about access, and then range of options. So what does it mean to talk about voice when we talk about disability or persons with disability? When we talk about voice, we want to ensure that there is an effective voice and that there's free choice, that people can have their voice heard and that they can make choices that are relevant to the specific context or specific decision that they're about to make. And it's also about, as I said earlier, the turn from expert knowledge to experiential knowledge. So the first stage for voice, when we talk about disability, is legal personhood and legal capacity. Because the first obstacle for disabled people to take a part in decision-making that relating to their own life is the question of legal capacity and guardianship. So as we know, or some of us know, the CRPD, the Convention on the Rights of Persons with Disabilities, in Article 12, discusses equal recognition before the law. And states who signed this convention, and Israel signed and ratified the convention, as well as many other countries around the world, states that signed the convention are obliged to respect the rights of disabled people to recognition everywhere before the law. They also are obliged to allow disabled people to enjoy legal capacity in all aspects of life, and this is important here, to provide access to the support that they may require in exercising their legal capacity. And this is what we call now supported decision-making. So when we think about legal capacity, we shouldn't think about, okay, people with disabilities should be able to make their own decision on their own, but we should think about the supportive mechanisms and the support that they may need in order to make decisions for their own. So it's not only about let me make my own decisions, but it's also about creating the mechanisms that allow people not only to have a formal voice, but also to express their preferences and eventually make an active choice. So when we think about supported decision-making now, we're thinking about mechanisms that assist disabled people in considering their options, understanding their ramifications, and executing these their decisions. In the context of healthcare, all this discussion is very relevant to informed consent. What does it mean to allow disabled people to make decisions and not to ask their guardian or to take any other form of substitute decision-making to make decisions for disabled people? And what we see often is that people with disabilities are discredited and their own knowledge or their own preferences are put aside. What this revolution of supported decision-making and their demand for individual voice actually demands from the health system to be able to listen, to give disabled people a voice as anybody else has, and to allow them to make their own choices and to execute their choices and to work according to these choices with the support that they need. Now, the next component, voice is not enough when we talk about disability. We need access. And access is important in two main contexts, I think. One is access to information. People cannot make decisions and cannot make choices without access to the information that they need. So if we think about the healthcare context, it may just mean having a sign language translation for people with disabilities, for people with hearing impairments. It might mean simplified language for people with cognitive or intellectual disabilities. So we need people with disability or other measures for people with visual impairments. So we need people to be able to have access to information in order to make informed decisions. It's not only about, okay, just say what you want to say. It's also about giving the information that you need in order to process and make your own decision. And the second component here is access to courts, to legal hearings, to administrative tribunals, and other medical committees, because if we want to have, if we discuss here throughout the day psychiatric committees, we may ask whether people with disabilities have access to psychiatric committees. First, there might be a person with a physical disability that is also standing before a psychiatric committee. Whether this psychiatric committee or the place or the hearing itself is physically accessible for people with all kinds of disability? No. I see a big no here. So what about people with visual and hearing impairments when they appear before a psychiatric committee? And the second question is access to the process itself, to understanding what's going on in the process, to the various documents that might be submitted in the process. So it could be a court. It could be a court hearing, but it could also be a psychiatric tribunal, a bioethics committee, a social security hearing. All these events where medical knowledge is part of the decision, we should still think whether they are accessible for disabled people. And here I think when we go to the CRPD, to the Convention on the Rights of Persons with Disability, we should look at Article 13 that talks about access to justice. And here we see that state parties are obliged to ensure effective access to justice for persons with disability, including procedural and age-appropriate accommodations in all legal proceedings. So what does all legal proceedings means? It might be open for interpretation. My interpretation is that it includes every semi-legal proceeding and every proceeding that might affect a person's liberty or other benefits or entitlement, as I said before. And then the third component, it's not only about voice and not only about access, it's also about range of options. And here, in order to have range of options, we need to have open and accessible public and private spheres. We need to have options for living arrangements, options for employment, and options for healthcare services that are barrier-free, inclusive, affordable, and of equal quality as other people receive. So again, it could be in the context of psychiatric treatment. It could be the question of what are the options. Is my only option is staying at home or being committed to a hospital? I might prefer being committed to a hospital, but I might need, and we discussed it here in the previous sessions, if there are other options, so if the range of options is wider, so other options, so my choice is real, is true, is effective. But if I don't have any other option, then I might choose the option that I wouldn't want in other conditions. It could be in questions that, okay, so just another example is accessible healthcare. So we had a huge, an interesting struggle in recent years about making a gynecological clinics accessible to disabled women. What we realized that there is only one in the center of Israel in Bnei Brak, interestingly. There was only one accessible gynecological clinic accessible in Israel, and all women using wheelchairs didn't have an accessible clinic to go to. So these are issues that are not bioethical in the narrow sense of bioethics, but it's about how to make the healthcare system more accessible to disabled people. And here we see in the CRPD that Article 25 talks about health and it discusses health, and states and Israel is actually now obliged to provide persons with disability with the same range, quality, and standard of free or affordable healthcare and programs as provided to other persons, to disabled people as well. And these healthcare services should be close as possible to people's own communities, including in rural areas. So this is this kind of these components of this section really put an emphasis not only on voice and access, but also on range of options that allow people with disabilities to make a meaningful decision. Now, the second component is the collective dimension. In terms of collective dimension, I would like to go briefly what it means to have a collective representation in public deliberation processes. Here again, I think that when we think about collective representation, we should take into account legislative processes, regulatory debates, policy making, adjudication process, public committees, statutory committees, and bioethics committee. We should always ask who is in the room and who is part of the decision of the public deliberation process. And I'll just go quickly and say that we should consider both the physical dimension and the intellectual dimension. In terms of physical presence, we should always ask whether there are disabled people in the room who are participating in public deliberation. But we should always know that people with disabilities are not always visible and are not always open about their disability. So there could be people who are closeted and they are there, and there could be people who have invisible or unapparent disabilities that we don't know actually. We cannot count wheelchairs in order to understand how many people with disabilities are here in the room. In terms of this intellectual presence, I think it's important also to emphasize that it's not enough to have disabled people in the room. It's also important what kind of language is used, whether we discuss whether we have a disability rights perspective in the room, whether people and the disability rights perspective can interestingly be carried by people who are non-disabled. So what is the role of non-disabled people in these public deliberations as kind of disability allies? So the question of representation in the physical intellectual presence is very challenging, but still we have to be concerned about it, whether there are disabled people in the room and whether a disability perspective was brought to the table. Here again, we should also think about a range of voices, plurality of impairments, intersectionality, women with disabilities, Arab with disabilities, people of all kinds of minorities with disabilities. Do we have only white males in the room, or whether we have a variety of people with disabilities with all kinds of impairments and with all kinds of backgrounds. And again, also plurality of perspectives and worldviews, not just plurality of disabilities, is important here. And the CRPD interestingly mentions that. So the preamble to the convention stresses that we should be concerned about the difficult conditions faced by persons with disabilities who are subject to multiple or aggravated forms of discrimination on the basis of race, color, sex, language, religion, political or other opinion, nationality, ethnicity, and etc. So when we think about all that, we should consider that we should understand, I think, finally, that when we talk about disability, when disability matters, it's not only in disability rights issues, it's also about health, welfare, and bioethics issue, and actually in all matters of life. So the question of nothing about us without us, it's not only about discrimination, it's also about bioethics, about access to healthcare, and the other issues as well. And I think that my time is up, right? So we should think, I think, more about the interplay between the collective and the individual, between the substantive and the procedural, when we think about promoting disability rights and allowing disabled people to take part in these processes.